That we've been very proactive in recent years on e-filing. Lawyers now can just push a button and get the factum in. Of course, they have to write it first. It's not quite that simple, but they don't have to send someone over physically with paper. We like to have one paper copy eventually, but we are encouraging e-filing. If you go into the Supreme Court of Canada courtroom now, you'll see computers at all the lawyers' desks. We encourage the use of computers even to bring up evidence that we're looking at and so on. We're not there yet, but we're trying to work toward a situation where less paper is consumed in the context of hearing each appeal than was once the case, and which of course adds to the expense and so on of appealing. Now, many people ask me, how does the court go about deciding its cases? Well, the first process is, as I mentioned, the leave process. And the leave process is, the leave applications still come before a panel of 3 judges who decides. But without going into the details, time doesn't permit it, every judge of the court gets a chance to look at every application. And so sometimes you'll have a panel saying, well, I think we should dismiss, and another judge will say, no, I want to raise this at our meeting. And so we have meetings once a month where we discuss these things. And it's quite an open process. And I hope one, well, never perfect, but for the most part, manages to choose the issues of public importance. After the leave is granted, the parties, of course, prepare factum, interveners prepare factums, and all of that is filed, and the judges all prepare. We have, as I mentioned, time limits, usually an hour for each side plus time for interveners. That means that the way the case is actually heard and processed is different. Gone are the days when the court would walk in, tabula rasa, okay, counsel would stand up and say, this case is about, spend the first morning going through the facts, the first afternoon going through the law, and then the next one would do the same thing on the second day. Right now, the way it operates is that all the judges know the facts, they know the legal arguments, they've read the factums, they've read the judgments of the court appealed from in the trial court. And so they are thoroughly familiar with that case. In addition, they probably read a memorandum from their law clerk outlining the different arguments that are put forward and commenting on them. So we come into court very well prepared. That means that we have to put in hours and hours and hours before we ever get into the courtroom. And it's not something you can fudge on, because the lawyers can tell right away whether you're prepared or not. We assure counsel that we know the case, and it has to be the fact that we do know the case. Then you say, well, what's the point of the hearing? What happens on the hearing? Well, the point of the hearing is to engage in a discussion about the legal issues. Now, some of you may have detected that from time to time your law professor tries to engage you in a discussion about the legal issues. The law professor says, it's not just about typing down what I take down. I want to get you thinking. I want to get your mind going. I want to get you working on different alternatives. I want to get you challenging me and making counter-arguments. That's what you need for the Supreme Court of Canada. A lawyer who simply gets up, has a lovely factum, and reads it is not doing a good job in our court. Nor is a lawyer at the other end of the spectrum who gets up and says, well, I've got a really interesting problem here. Justice requires a solution. Now you judges go and figure it out. We want to engage with the counsel on the legal issues in the case. And so we ask questions, and we hope to get responsive answers. And so if and when you get to the Supreme Court of Canada, be prepared to give responsive answers. Know your case inside out, and think about what questions the judges could answer, where are the weak points, where are the strong points, how are you going to answer to this particular question should it arise. So our hearings are lots of fun. They're active and very, very interesting as a rule. After the hearing, we immediately conference in our conference room, usually. Sometimes it's delayed for whatever reason, and a few days. And we discuss the case. We usually just have a free-for-all, just if it's a complicated case, to get some thoughts out, and then we go around, starting with the junior person, and each person says what they then think about the various issues. And at that point, you get an idea, the chair gets an idea of where how the decision is going to go, where the majority might lie, or whatever. And at the end of a 2-week period, as Chief Justice, I make an assignment, writing assignments for the cases based on who's interested in the case and who's in the majority or with the majority side. And the next step then is writing those judgments, which is one of the most interesting aspects of the job. And the justice goes away and works on the judgment. It's circulated. There may be an indication of a dissent at that point or concurring reasons. Then when all of that process is done and the votes are in, editing, translation takes place, and the judgment is released. The executive legal officer has a press briefing to ensure that the press is able to understand the importance of the decision, answer any questions that they might have. And this has helped a lot, I might say, in improving the depth and accuracy of reporting on our decisions. So let me just say this in conclusion. The Supreme Court of Canada is, I think we'd all agree, an institution fundamental to Canadian democracy. I was reading the other day, and I came across a quote by Adam Smith, and this is back in the 18th century. For a country to be successful, basically, he said you have to have 3 conditions. You have to have peace, you have to have easy taxes, I'll leave that for you to and you have to have what he called a tolerable system of justice. It's now generally accepted, I think, in our world that a strong and independent judiciary is a precondition for good governance and democracy. Canada is a constitutional democracy. It has 3 branches of government: legislative, executive, and judicial. All are essential, and each must respect the roles and responsibilities of the other. In this scheme, which we call our Constitution, the Supreme Court of Canada plays, and I hope will continue to play, a responsible and vital role. So that concludes my formal remarks, and I think we have at least 20 minutes or so for questions and interaction.